Hi, this is Dan Smith of DPS Legal Counsel. Today I want to talk about negative online reviews for your medical practice or your dental practice. What can you do about them? What should you do about them? Let's talk about that. So first of all, let's say that you're in practice and one of your patients you discover has gone online and in either one of the databases that's out there for online reviews for healthcare practices, or through maybe just Facebook, whatever, Twitter has made a negative online review or statement about you or your practice. What can you do? What should you do? What should you not do? Well, let's start with what you should not do. The first thing you should be clear about don't do this is do not respond in kind online to a negative patient review. Because of the limitations imposed by HIPAA, you would be taking a big risk about getting in trouble for a HIPAA violation if you even acknowledge that the person who made the negative online review of you or your practice is even a patient of yours. So do not engage with the person who gave the negative review. Do not respond to the negative review. Do not do that online. Do not give that person the opportunity to claim and really to show that you have engaged in a HIPAA violation by even acknowledging the patient relationship. So first of all, don't respond online to an online negative review. Do not even acknowledge it online. Don't speak to it online. You do not want to be in violation of HIPAA. The second thing you should not do is immediately sue that person for defamation. Defamation is essentially making a false statement of fact that damages a person's reputation. It has two prongs to it, or two parts to it. You have defamation that is oral in nature, and that is called slander. And you have defamation that is written in nature, and that is libel. But the same thing really applies to both libel and slander. It's a false statement of fact that damages a person's reputation. The reason you don't want to just fly off the handle immediately and file a defamation lawsuit against your patient who left this online review is because in order to sustain a case for defamation, you have to show that it is an untrue statement of fact. In other words, it cannot merely be an opinion. And so if the person has said, "You're a terrible doctor, don't go to this doctor doesn't care about you," and says all kinds of negative things that damages your practice, damages your reputation, but those things fall within the spectrum of being opinion, you're not going to be able to sustain a case for defamation. It would have to be a provably untrue statement of fact. Now, there could be things that a person would say in an online review that would fall in that category of a demonstrably untrue statement of fact, but don't just fly off the handle and sue someone who gives you a bad review, because you have to make sure that it is an untrue statement of fact, not merely an opinion. Of course, you should also be able to show before you file your lawsuit that you've suffered some damage in your reputation. So, but that's a second part of a case for defamation. The biggest thing before you decide that that's something you were going to pursue is to make sure that it's not merely an opinion. So what do you do then if you get a negative review online and you can't respond in kind online because that would be a violation of HIPAA, and you can't just run to the courthouse and file a defamation lawsuit because you need to be sure that you meet the requirements for defamation. In other words, that it's not just a statement of opinion. What should you do? Well, I would say there are about 3 things that you should do generally in this whole sphere of online reviews and the possibility of getting an online negative review. First of all, be proactive in your practice if possible, and invite your patients, especially those who you may have long-term relationships with and you know are happy with your services, which should really be just about everyone. Invite those people to leave you online reviews. That way, if you do get an occasional negative review, it won't be the only one that's out there. It won't be the only review you have. It may just be one review out of hundreds, and most of the reviews would be positive. So be proactive, or at least consider being proactive and asking for reviews from your patients. Second thing is, if you do get a negative online review, you should probably just reach out privately to the patient and see if you can address their concern. And it may be that you're able to do that, and they may even come back and remove the negative review or expound upon the fact that you have reached out to them and you've talked to them and they feel good about your practice now. And so you can maybe mitigate the damage by just reaching out and trying to resolve matters privately with your patient. Now, be careful when you speak to your patient, because anything you say, anything you put in writing, anything that the patient could take offense to could find its way again online. So you have to be cautious about how you approach an angry patient who has already given you an online negative review. You may want to speak to an attorney about that and see if that is something they can advise you on and help you with the public relations issue that you have now with this former patient. If after reaching out to the patient and trying to resolve it, you're unable to do it, and you still feel that this is not only damaging to your practice, but it is an untrue statement of fact, you probably should talk to an attorney about sending a letter, a cease and desist letter or a takedown letter to the patient who wrote the negative review, to see if a letter from the attorney might prompt the former patient into taking down the negative review. Again, you just have to be cautious in this area because you don't want to make things worse by actions that you take. So I would advise that you speak to an attorney and go through all the facts involving your situation to see what might be the best course. But that is something you should at least consider. If you decide, if you don't get any action from trying to work with the patient, either yourself or through your attorney, and you really are, after having been advised by your attorney that you do have a case for defamation, the next step would be considering filing a case for defamation. Now, when you do that, you still need to be careful about HIPAA and what you file. You may need a protective order before you disclose anything specific about your relationship with the patient on the public record, and you need to be prepared for what may come your way from a filing of defamation or filing of a defamation suit against the former patient, and that is what is called an anti-SLAPP suit. SLAPP is an acronym. It's spelled S-L-A-P-P, and it's an acronym for Strategic Lawsuit Against Public Participation. And an anti-SLAPP suit is essentially a lawsuit that a defendant in a defamation case files against the party that brought the defamation case in the first place, saying that that party, in this case would be you as the doctor or you as the medical practice, that you are trying to chill freedom of speech and communication by that patient on a matter of public concern or public participation. There are a number of states that have anti-SLAPP suit legislation, and Tennessee is one of those states. Tennessee passed an anti-SLAPP suit law that went into effect in July of 2019. And essentially what it says is that if a person gets sued because they made some type of communication on a topic or with respect to a matter of public concern or public participation, then unless there is a good basis for that lawsuit, a court will not only upon request by the defendant may dismiss the case entirely against that defendant, but the court could also sanction the party who brought the defamation case in the first place by imposing a monetary penalty or sanction against that party, having them pay the other party's legal cost and court costs for filing the anti-SLAPP suit case in the first place. And in effect, it would it's a protective measure for people who may find themselves defendants in defamation cases fighting back against a case that potentially would be a chilling or limitation on a person's freedom of speech. Now, the SLAPP suit legislation requires that the matter that the person spoke about, and in this case would be their online negative review, it requires that that matter be something of public concern generally. But public concern is defined very broadly in the statute, and it includes things of health or safety, community well-being, service offered in the public marketplace, or anything else that a court may determine is a matter of public concern. So you can see that a patient or a former patient who leaves an online negative review of a doctor or a dentist could potentially say in an anti-SLAPP suit filed against the doctor or dentist who brought a defamation case, could say this was a matter of public concern, this was a matter of public well-being, community well-being, this was a service that the doctor or the dentist was offering to the public, or court, look, this is a matter of public concern, this is a good case to fight back against the doctor or dentist who brought this frivolous defamation case. So all that to say, before you run to the courthouse and file a defamation lawsuit against a former patient, be advised and be on notice that not only are you going to have to prove that the statement was a matter of a negative, the negative review was a incorrect or false statement of fact that you can prove and not just an opinion, but you're going to have to perhaps fight back against an anti-SLAPP case brought by the patient once you sue them for defamation. And then finally, even if you were to win and prevail on your defamation case, a couple of things are going to happen. First of all, your dispute with your patient is going to be in the news, and you're going to be dealing with that disgruntled, unhappy, negative patient for a long time through the course of this litigation. And if you were even to get a judgment against that patient, is that judgment going to be able to be paid? Is the patient going to be able to have enough funds available to pay you whatever damages a court might decide you're entitled to, plus all the costs and expenses you've paid to your attorney and handling the lawsuit? So just be cautious before you file a lawsuit. It's easy to file a lawsuit. It's hard to get out of a lawsuit, and sometimes even a meritorious lawsuit is something that you might not want to bring depending on the circumstances. All right, so in conclusion, if you get a negative review, don't respond in kind. Don't go online. Try to work things out with the patient privately if you can, and speak to an attorney about what your rights and what your possible remedies might be. I hope that helps. Good luck with everything with your patients, and we'll see you next time.